If you bring a lawsuit for medical malpractice against your doctor, and now you are examined by a doctor for the defense to see the extent of your injuries, is it possible that if your case goes all the way to trial, the defense attorney won't even call in the doctor who examined you on their behalf to testify? You want to know the answer? Come join me for a moment as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness was a cause of your injury. And now during the course of your lawsuit, the defense wants to have you examined by a doctor of their choosing. They call this an independent medical examination. Well, guess what? There is nothing independent about it. They hire that doctor to have you examined. And there's only one reason alone why they want you examined by their own doctor. And that is to try and reduce or minimize the extent of your injuries. They are going to dispute everything they possibly can to show that your injuries are not as bad as you claim them to be. So now, what happens at the time of trial? Typically, what will happen is we will bring in your treating doctors to explain to the jury and say, ladies and gentlemen, here, Mrs. Jones has all these following problems. Mrs. Jones is going to tell you about them in her own words. And plus, we're going to bring in her treating doctors to show you and explain to you in detail why she is disabled and why she can no longer do those things that she ordinarily could do. And now, after we are done putting on all of our proof and bringing in all of our medical witnesses, the defense has an opportunity to go ahead and put on their own witnesses. Maybe it's a medical expert who is now disputing how this incident happened, who's disputing that the doctor violated the basic standards of medical care. And they will do that in every single instance. But now, think about this. The defense, during the course of your lawsuit, has had you examined by a doctor of their choosing, who has drafted a report that basically says, hey, Mrs. Jones, you're a malingerer. You're a faker. You're making this whole thing up. Or, if you do have an injury, it's really not that bad. It's pretty insignificant. So now, during the course of trial, the defense does not bring in this witness to testify. And you're sitting there wondering, I don't understand. They've just notified the judge they have no more witnesses. Now they just told the judge they have no more proof to put on to dispute your claims. And you're wondering, how is that possible? You know that you were examined by a doctor. The jury doesn't know that yet. Why? Because they don't know what happened during the course of your lawsuit in the events leading up to trial. All they know is that you have brought this lawsuit against the doctor. They've heard testimony from various witnesses, and now they know nothing about this independent, which is not, a medical exam by the defense. So what happens then? Well, I'll tell you what will happen. As your case gets to a close, your attorney in private will ask the judge to do a couple of things. Your attorney will ask the judge to give the jury a legal instruction that says, hey, judge, the defense examined my client, and for whatever reason, they chose not to produce that witness to testify. I want you to give the jury a specific instruction that says, hey, the defense did have this patient examined by a doctor, and because they have intentionally chosen not to bring this witness in, now the jury can infer the most significant conclusion because they did not call him. And what conclusion can the jury reach? That this witness, that this defense witness would have nothing helpful to offer to the jury. And in fact, it would be favorable to the plaintiff, to the injured patient. That's what we want the judge to instruct the jury on, so that now they can infer, because they did not call this witness to testify, now the jury can go ahead and get in their minds, you know what? If this doctor had come in, his testimony would not have been favorable for the defense. Otherwise, they would have called him in to testify, right? But because they have not called him in to testify, now the jury can go ahead and say, hey, the only reason he didn't come in and testify is because he would not have been able to say anything favorable for the defense, and in all likelihood, it would have been detrimental for him to testify for the defense. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what happens in these medical malpractice cases where patients are examined by doctors for the defense. And now, for whatever reason, the defense choose not to bring in that doctor to testify. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.